Hello everyone, it's injury attorney Ryan Pauley here, bringing you my video blog post, Have You Ever Wondered? During each post, I talk about a legal topic that you might have wondered about. This could be something that's in the news, or something you just encountered in your daily life but said, I wonder about that. Last month's blog post was, Why should I care who's on the Supreme Court? And following with the Supreme Court theme, this month's post is, How do cases get to the Supreme Court? I thought it would be helpful to talk about how cases get to the Supreme Court in light of the lawsuits that were filed by former President Trump regarding the election. So, how do cases get to the Supreme Court? There's three things you need to know to understand how cases get to the Supreme Court. Number one, what is the Supreme Court? The United States Supreme Court consists of 9 judges that are appointed by presidents for life. And they are the highest court in the land, meaning you cannot appeal a decision that comes from the United States Supreme Court. Second, how do cases get to the United States Supreme Court? And this is the meat of our post. And there's two ways in which cases get to the United States Supreme Court. The traditional approach, which is appeals from lower courts. Essentially, under this approach, there would be a decision by a lower court, a district court, and one of the parties is not happy with it. They would then appeal it to the Court of Appeals in one of the circuits throughout the United States. And then, if they're not happy with that decision, a party can attempt to appeal it to the United States Supreme Court. This traditional approach can take years. Now, there is an exception to the traditional approach, which I call the chat and cut. And the chat and cut means that if the issue that you bring in front of the district court is of imperative public importance, then the first adverse ruling you get, you can appeal directly to the Supreme Court. So that's the chat and cut exception. Now, the second way in which a case can get to the Supreme Court is if the Supreme Court exercises original jurisdiction. In this case, one of the parties would just file a lawsuit directly in the Supreme Court. Now, this is extremely limited when this can happen, because the original jurisdiction will only happen when there are disputes between states. So that's very limited. So that's how cases get to the Supreme Court. Now, once they're to the Supreme Court, doesn't mean they automatically get heard, which brings us to the third topic, which is how do the judges decide which cases they hear? Now, it's important to remember something called the Rule of 4. Under the Rule of 4, if 4 of the justices on the Supreme Court decide that the case in front of them has merit, then it will proceed into the Supreme Court and will be heard by the Supreme Court. However, if those 4 judges, there are not 4 judges that agree, the case is not heard by the Supreme Court, and the court that made the ruling that was appealed stands as the final ruling in the case. So, we now understand what the Supreme Court is, how cases get to the Supreme Court, and third, when they're there, how does the judges determine if they're going to hear it or not? So, with that understanding, we talk a little about the lawsuits that President Trump had filed. Now, these again can be broken into 2 categories. The first concerns Georgia, Michigan, Wisconsin, and Pennsylvania. These went through the traditional approach, and they were able to exercise the chat and cut exception because the lawyers argued that the issues were imperative public importance. Now, the Supreme Court ultimately didn't hear the case because they didn't agree with those arguments. Now, the second type of lawsuit that was filed was by the state of Texas. The state of Texas was not exercising the traditional approach, but asking the court to have original jurisdiction because it argued that the dispute was between Texas and the other states, and that because these other states didn't hold elections correctly, it was impairing the rights of the people in the state of Texas. Again, the United States Supreme Court did not agree with that, and it was not heard by the United States Supreme Court. So, here's the takeaway. It takes a very long time to get to the Supreme Court. And if you qualify for the chat and cut exception, or if you have original jurisdiction, that can shorten the time in which it takes you as a litigant to get there. Now, some people have asked me, Ryan, have you ever been to the United States Supreme Court? And I've never argued a case in front of the United States Supreme Court. But if you keep sending cases my way, one day I might be lucky enough to do that. So I hope this post has helped you understand how cases get to the Supreme Court. Of course, if you have any questions at all, feel free to email me or just give me a call. Thanks again, everyone. Take care.